a bad signal, so I had to move somewhere. And hopefully you can. Looks like I've got a decent signal now. All right. So let me just pull something up really quick. Sorry, it's been I had a hearing and then trying to find a signal has been crazy. Just want to pull something up real quick. Oh, well, I'm not worried about that. All right, guys. Hey, so what I wanted to talk about is the fact that, yeah, I got to have the glasses on. And I get a lot of clients who come to me and they've got really good cases. And I'm like, holy cow, I can't believe that they've gotten away with that. And they, just got their case dismissed. And they're like, yeah, so I want to sue them. I'm like, okay, good. Yeah, you've got a great case. So when did all this happen? And if you're going to sue under 1983, the biggest problem is that the statute of limitations on a 1983 case, a 42 USC 1983 case, is 2 years. So, oh, look at that, my collar. I hope that hasn't been up the whole time. So the statute of limitations is 2 years. Now, it's 2 years from the incident itself. So let's go through something. You get, I guess a lot of my cases are First Amendment cases. So you're out, filming a police stop, right? And the police don't like it. They try to tell you unconstitutionally to move somewhere, and you don't. And they arrest you for interference when there's obviously no interference. You're obviously very far away and all of that. And let's say this happens on January 1st, okay, of this year, 2024. And of course, they charge you with interference. It's bogus. They violated your rights. They've falsely arrested you. They've arrested you for protected activity, etc. And they formally charge you a few months later than that, and they drag it on. And then in March of 2026, they finally dismiss the charges. And you're like, woo, yay! Now I'm going to sue them assholes for violating my rights. Well, sorry, can't do that because the statute of limitations begins on January 1st, 2024, when the actual false arrest happened. Now, there's one caveat to that, and that is the only thing that would survive is what is called malicious prosecution under 1983. And the malicious prosecution statute doesn't start tolling until your case is dismissed, until the charges are dropped against you. Now, that's a savior for some people if you're going to do a malicious prosecution, but it only leaves malicious prosecution. And the problem with that is a malicious prosecution claim is somewhat difficult because you have to prove malice. Not only do you have to, the charges against you have to be dropped, which that's one of the elements, which is why the statute of limitations doesn't start tolling until that day instead of when you're falsely arrested. But it starts when it's dismissed. So that's the first thing, is they have to be dismissed. You have to be innocent. And what that means is just because they dismiss it doesn't mean that you're innocent. It just means they don't want to pursue it. Maybe it's just not worth it. Maybe it's too politically sensitive for the prosecutors to go after this particular charge. But for whatever reason, they think that there's probable cause, and they just don't, charge you and decide not to fight it. And some of those do exist. I've had a few of those cases where they think that, look, this is what we could probably prove. And, they might have probable cause. They might have reasonable suspicion, but they don't have the beyond a reasonable doubt standard that is required in a criminal trial. And so then the actual innocence, if you were to do a malicious prosecution, you're always going to see what's called a 12b6 failure to state a claim for which relief could be granted because of qualified immunity. And they're going to say, well, look, just because we dismissed it, we didn't prosecute this with malice. Look, we legitimately think he was interfering here. This was up to officer discretion, et cetera, et cetera. So you've really got to have a clear-cut case of malicious prosecution in order to take advantage of the extra time that the dismissal will give you in a 1983 case. But let's just say you've got other issues, right? You've got the Second Amendment issue, the First Amendment issue, the Fourth Amendment issue. Those issues start on the day that you're arrested or the day that those things happen. And a lot of people think falsely that, okay, my rights were violated. I've got to get through this criminal case before I can file a civil case. And that's not true. You can file a civil case the same day that you're arrested and that you're going through the criminal case. Now, a lot of attorneys don't like to do that. And I've learned this firsthand because this is what we did in my first arrest in 2013. And we learned from it that when you file a large lawsuit against the bully thug that arrests you, that only gives the city or the county more incentive to convict you, because if they can convict you, then that gets your civil case thrown out the window. So it's best to try and wait as long as possible. So if you think you have a criminal case because you've been falsely arrested, the first thing you need to do is take out your phone and set a date about 1 year and 9 months in the future. Okay, from that date that you're arrested. 1 year, 9 months. Hey, delete laws. Thank you, sir. Appreciate you. And why do I say that? Because you don't want to wait until the last minute of the 2 years and then go find an attorney, because a lot of attorneys are very, very busy. I mean, trust me, anybody that's been contacting me lately knows that I'm incredibly busy. I'm overbooked. I probably have more cases than I should. I don't, but I can't take any new cases right now, right? So if you come to me and say, dude, I've got like 10 days and my statute of limitations runs out, I'm gonna be like, dude, sorry, man, I can't help you. It's just, unless you're willing to pay me a lot of money to put everything down and at least help you draft something that you can file pro se to at least secure your right to sue. So at 1 year, 9 months, that's when you go find your attorney. When you get that, if your case is still waiting, it's still being dragged out, then at 1 year and 9 months, go ahead and file your lawsuit. And then what you can do, but the other party might do, is ask for a stay on that lawsuit pending the criminal charges to be dismissed. Now, you can also do that. You can file your lawsuit, and then you can also file a motion to stay, because you're just trying to make sure that you hit the statute of limitations before it runs out and protect your right to sue. And a lot of times I've got a case in Belton right now where that's exactly what happened. We sued the police. It's been 2 years and they still haven't charged this guy. And he was about to lose his opportunity to sue. So we filed the lawsuit. And of course, exactly as planned, the defendant officer's attorney filed a motion to stay, which we did not oppose. And the reason we didn't oppose it is because obviously an acquittal helps us as well, as much as a guilty verdict helps them. And I'm pretty confident there's not going to be a guilty verdict. In fact, the fact that they keep pushing this case back only tells me that they know they don't have anything. But there is a civil case waiting in the wings for when that case is over with. And I can't wait to sue those cops over that. So that's the important thing, is at about 1 year, 9 months, you go ahead and you start contacting your attorney. That gives you time to find an attorney, and it gives the attorney time to draft something within that 2 year timeline. The second thing that is really important is that you understand that in a civil case, just because you have a claim and you have a constitutional violation, you're likely not going to get anything out of it. You know, a lot of people think they have these multi-million-dollar cases. Oh my gosh, I've got this case and I'm going to sue for $107 million. Little word of advice to everybody, just so you know, if for the most part, except in like personal injury type cases, for the most part, if you are living to sue a police officer, you're not looking at 7 digits. Okay? If you are still alive and able to hire an attorney to sue the cops who violated your rights, you're not looking at 7 figures. You're not looking at high 6 figures unless it's incredibly egregious. It had better be really, really egregious for you to get even over $500,000. And I'm talking settlements for the most part, because a lot of these cases, especially as you get through discovery and you realize, oh, yeah, maybe we did violate his rights. They're going to try and settle, but you're not going to get that much money. And then in a jury trial, you're probably not going to get that much money either, because there's this belief by most people in society that when you sue the city and the city loses, or you sue the county and the county loses, that that's taxpayer money, when really it's their insurance pool. They have what's called a risk pool, at least here in Texas they do. And that's why the risk pool a lot of times is involved. If you're a felon out of a different state, can you hire a lawyer in Texas to get your expungement? No, sir, you cannot. Not unless that lawyer is also licensed in the state where you need the expungement. Now, you can hire a Texas lawyer if you need a Texas expungement. In other words, you were convicted here in Texas, but you now live somewhere else. Yes, you can, but you can't. I can't go and help somebody with an expungement in Tennessee. So getting back to the trial thing, and what's also important is that during your criminal trial, make sure that your attorney makes some proper arguments about the constitutional rights that have been violated. Your 4th Amendment, your 2nd Amendment, your 1st Amendment, 14th Amendment. Hey, Brent, thank you, man. Thank you for that, $19.99. Appreciate you. He says, you the man. I'm a man. Let's see. So, yeah, the money thing. You're just, unfortunately, you're just not going to end up getting a lot of money. A lot of the cases that I do, and I take cases that most attorneys won't for several reasons. One of the reasons is, hey, take care, Hawkwind. One of the reasons I take clients is because no other attorney will. I take a lot of what I would define as problem clients. These are people who are hot-headed sometimes. They're very mouthy. They might be what some call a sovereign citizen. They think that the law doesn't apply to them, that kind of stuff. And a lot of attorneys don't want to mess with those kinds of people. Now, I'm a former first sergeant. I can deal with problem children. And if their rights have been violated, even problem children have rights. And so I like to take those kinds of cases. The other types of cases I like to take are the small ones, the ones where you're not looking at 6 or even 5-figure settlements. Somebody gets blocked on Facebook. I mean, for that's a violation of your rights, but it's not worth a lot of money to a lot of people. And look, you're not going to get a whole lot of stuff. My MOS was 35 Yankee, and I was a 35 Lima before that. When I became an E8, it went from 35 Lima to 35 Yankee. And so, what was I saying? Hey, Flying Otter, thank you, sir, so much. I appreciate you, man. From a fellow vet and a Texan Coco. And I can't wait till about a week and a half now. I'll be unveiling my Texalorian costume at the Bell County Comic-Con. Crap, what was I saying? I got to stop. I got to stop doing that. Oh, yeah, so like little money. So somebody gets blocked on Facebook, and I get hired. And here's how I do this. It's a $250 all I ask for initially. And that covers 2 letters. It covers essentially a demand letter to get that person unblocked, but there's no strings attached to that. And then I give them generally about 5 days to unblock my client. If they don't unblock, I send a second letter saying, okay, you've had an opportunity to stop violating my client's rights. You've been made aware that you were violating my client's rights, and you've refused to rectify that situation. So now we are demanding an amount of money. And usually it's $8,000 is what I say. So now, in order to avoid litigation in this matter, and I present all the case law and everything about the fact that politicians can't block you on Facebook or Twitter or anything like that. But now that I've made you aware and you still refuse to do the right thing, my client is willing to not file a suit against you if you're willing to settle for $8,000. And I will tell you that I've been very successful in these, and the awards range from about 4,000 to 8,000. Okay. No, I don't wear these shades in court. You know, a lot of people don't. I guess I should say this. I do wear shades in court. It's not these. They're smaller, but I get migraines, and I'm very light sensitive ever since Almost Park. Well, even before Almost Park, I've always been kind of light sensitive, but Almost Park made me even more light sensitive. So I have to wear, when I'm outside, and if it's bright outside, I have to wear dark sunglasses, and they generally have to, I can't be able to see around them because if light, you know, if there's light around here, it adds to the migraine. So they've got to kind of wrap around. And that's why I wear these. Now in court, I've only had to do this once, one day even, where I came down with a migraine and I'm very photosensitive when it comes to a migraine, but I always let the judges know if it's a trial, because this only comes down to when it's a trial. And I always inform them, hey, if this happens, I have these migraine glasses that I have to wear because it blocks out. It's almost like a welder's mask, except you can see through them. Sorry, I like my Captain Planet glasses. If you don't like it, you can go watch the Teletubbies on another channel, I guess. So, where were we? Oh yeah, so, you know, those little things are the ones that I like to take. And I only get 25% of any of these. You know, a lot of attorneys ask for 40% of any settlement that they get. Now, a lot of attorneys also do stuff for free. Well, I say free. They pay for all the expenses, and, you know, you only pay if we win, right? Well, in the meantime, they're charging you 40% to do all that. And on top of that, you're having to pay those expenses, all those expenses that added up. You know, you got your $400 filing fee, you got your expert witness fees, you got your medical fees, you've got your deposition fees, you've got all the money that has gone into a case. When you finally get that settlement at the end, you know, you're thinking, oh, I just got $100,000. Well, no, you actually just got $60,000, because $40,000 automatically goes to the attorney. Oh, and on top of that, I've got $16,000 worth of expenses. So now I'm actually getting $56,000, and you're getting $44,000. And I've always just kind of had a problem with that, because I think that when somebody's injured or somebody's rights have been violated, why am I getting all this money? I don't think I should be allowed to have more money than in a settlement than my client. He's the one that was injured. And so I set my fees at 25% so that my fees plus expenses, if there are extra expenses, don't go over 40%. Does that make sense? That's just the way I like to do it. And and I haven't had any problems with that. I mean, I don't think I've ever been over 30% in total taking anything. But so that's kind of how that works as well. Finally, if you're going to sue the cops, you always want to be what's called a sympathetic defendant. All right. When you are having an encounter with a police officer, yes, you have every right to be as belligerent and profane as you want to be. But what you need to recognize is that video of you being belligerent and profane is going to go before, if it ever gets to trial, it's going to go before a jury. And you can be 100% right and the cop can be 100% wrong, but if they don't like you, they're not going to rule in your favor. This is a civil case. They're not going to rule in your favor. So always try to be what I call the sympathetic defendant, because when a jury's watching this video, you want them to see not you and what you're saying, but you want them to see the violations against your rights. You want them to see the excessive force. You want them to see the fact that you were doing nothing wrong, right? Now, I understand once you're placed in handcuffs, that's not what I'm talking about. Because when I start getting placed in handcuffs and I'm going to be thrown in a cage, oh, believe me, all of this advice goes out the window on my own behalf, because now I'm getting arrested. It's like, I can't talk myself out of an arrest now, so I might as well, if I'm going to be arrested anyway, by golly, I'm going to be arrested with my mouth. So But always try to be as cool, calm, and collected as you possibly can, because a jury's going to look at that and they're going to hold it against you. And keep in mind, a lot of juries have this unfounded love and reverence for law enforcement. And, you know, these poor guys, all they want to do is their job. And you guys had to come up and you had to film, you know, you had to watch them. But yet these are the same people that you don't mind being watched at every street corner. You don't mind being watched on all these traffic cameras. You don't mind being watched when you're, in a government building and there's cameras everywhere. But yet you have problems with us filming them. So there's that. Don't worry about Cure. Cure's just, yeah. Let's see. I thought there was one more thing about suing. So you just want to protect. Really, the main thing is just understand this is, if you get nothing out of this video, get this. You have 2 years. 2 years from the time of your arrest. And really, it's the time of your arrest. So even if they kind of violate your rights on the side of the street, it's once you're arrested, that's the new damage. So you can bring that in, the what happened before your arrest, if the arrest is part of what you did. I mean, for example, I've got a case right now where person acted, 4 months later gets arrested on what happened 4 months earlier, because the police officer on the scene tried to arrest my client on the scene, but the supervisor wouldn't let her. And so she waited a few months, and then she filed an affidavit, probably without his knowledge, and got him arrested. Now we got that case dismissed, but now we're suing, and we were able to sue because the arrest happened 4 months after the actions described by the arrest. Had he been arrested that day, we would have lost the statute of limitations. So the arrest was what kind of kicked it off again. And for malicious prosecution, though, remember, under a malicious prosecution case, the 2-year statute of limitations doesn't start until the case is dismissed. And to do a malicious prosecution, your charges have to be dismissed, okay? I will also say you can't, it's very, very hard and very, very rare to sue a prosecutor and or a judge, especially a judge, for malicious prosecution, because you've got to prove that they know you didn't do anything wrong. They knew that everything that the officer filed was false, and they went through this process of, making you come to court for a year every month before they dismissed it. Then you probably have a case of malicious prosecution against the prosecutor, because he's had all that discovery all that time. So that's why I always wait to do anything until I get discovery. I don't file anything until I get discovery. I look at it, and then I start filing my motions. For example, I have the case that I'm here for today in Madison County. It's an unlawful carry case because my client was picked up for a PI, a public intoxication, and then when they went to arrest her, they took her purse and everything, and when they were inventorying her purse, found out she had a gun in her purse. And under Texas law, under Texas unconstitutional law, if you have a firearm while you're quote unquote intoxicated, then it's a crime. Well, if you're just arresting someone for PI, there's no blood alcohol level. They don't, what does intoxicated mean? And so we're going to challenge the constitutionality that the law 4602 is unconstitutionally broad as it relates to carrying while you're quote unquote intoxicated, because what is intoxicated? And by the way, the gun was never used. It was never picked up. It was never held. It was never manipulated. Nothing. So the fact that you're charged with a crime for doing nothing more than having possession of something that's legal, there's something wrong about that. What about Leo's arrested for DUI and carry guns? See, they should be charged with that as well. They should legally be charged with that, because that's what the law says. Actually, I take it back, because 4602 and 4603 do not apply to law enforcement. So just like me, being retired, Wow, it just occurred to me because I use it mostly for courthouses and like schools. That's what I use my exception for. But I just realized 4602 doesn't apply to us either under 4615 of the Penal Code. And for me, it's 4615A5, I think is what I fall under for the exemptions. So, but yeah, so cops, that's why they don't get charged with it, because active duty police officers are exempt from 4602 and 4603. But yeah, there's something wrong with that. And I don't like the fact that even me, I don't even like the fact that I get separate rights just because I made a particular career choice at one point in my life and happened to stick to that career for at least 10 years. There's just something wrong with that. I don't think anybody, as a matter of fact, if you go and look at a lot of the gun bills that have been passed in Austin, where they were trying to say, okay, we're going to make an exception for poll judges, or polling location judges, or for retired magistrates, or for assistant district attorneys. I've always testified against those bills, or actually I've only testified on them. I oppose them in principle, but I support them in the expansion of rights. At least it's an expansion of rights for someone. I don't like who it is, but I've always testified that this is wrong. We shouldn't have different rights for government officials, retired government officials, and the regular public. I think once we retire from this profession, we should be, just like Washington said, a regular citizen again, a regular civilian. All right, what about the multiple incidents of harassment in the last act, and does conspiracy rules, when do they apply? It's the last act, yes. The last act would be where the statute of limitations begins tolling. They are profiting from illegal seizure. We had a client vindicated of trumped up charges. Guns seized illegally. We got them back, but it took 6 months to stall. Yeah, I've been doing a lot of cases where I'm getting people's guns back. I do a lot of those. I mean, I know the ATF lawyers on a first name basis now. Let's just put it that way. And I've been very successful. And by the way, I will be going to DC in October as a second chair in a J6 case regarding firearms. And I will be cross-examining witnesses on Second Amendment issues and the facts of this case. So I'm really looking forward to going to that. I don't have any updates on Jack yet, but things are looking very promising. I did send it. That's all I can say. That's all I can say. I know he said I can say a lot of things, but I also don't want to jinx myself. Let's just say things are looking good. And we had a hearing. It was either yesterday or the day before. Without turning this off, I wouldn't be able to look. Jason's case is moving forward as well. I had it's weird you're asking these questions. I had a call between the parties and the judge today on some issues, and was able to protect his First Amendment right. You can always look at the filings. If you go to the Followell v. City of Aransas Pass on Pacer, you'll see that there was an advisement, that was filed, and then my response to the advisement. And that's really the latest. We had a hearing today. We actually had a hearing yesterday, but I don't know what happened. I didn't get notified of it. And as I was coming out of another hearing I was in at the exact same time, I saw an email from the judge's clerk saying, hey, the judge is at the bench and we're waiting on you. And I'm like, waiting on me for what? And I start frantically going through all my stuff. I'm like, what did I miss? What did I miss? And I couldn't find it. And come to find out there was a hearing yesterday. But thankfully, I was able to explain everything to the judge today, and we're good to go. So I almost probably got fined or something if I'd done something wrong. But I was like, Judge, I mean, I'm not going to give you any excuses. I don't have any excuses. I'm just telling you I was unaware, and I don't know why I was unaware. So yeah, J6 case is in October going to trial, and I'm going to be second chair on that. They hired me specifically to argue the gun issues. All right, folks. That's all I've got. Just remember, please, the 2-year statute of limitations, because I hate when I go through a story and I talk to someone about suing and they've got their rights have been violated, everything is bad. And then I'm like, okay, so let's get the timeline down here. So when did all this happen? And then they're like, oh, it happened in April of 22. And I'm like, like what? I can't help you. Why not? It's past 2 years. Yeah, but I just got the charges dismissed. It doesn't matter. It doesn't matter. The civil side doesn't care about the criminal side. The statute of limitations doesn't wait for the criminal charges to be done. So always, if you think your rights have been violated, okay, no matter how little, how small, once that's done, put in your calendar somewhere. If you got a Google Calendar or whatever, a year and 9 months from that date, you need to make sure that you're looking for an attorney. And I only say that if you're facing criminal charges, okay? Sometimes it's also good to wait if you haven't been charged with a crime, but like maybe you got detained and they held you for like 30 minutes or something, or some unreasonable time, and then they let you go. You don't want to sue right away either, because then they might go back and just file criminal charges on you later, a few months down the road. So, and I know this hurts a lot of people to hear, but just wait about, that's what I'm talking about. It's a 1983, no, I'm talking about 1983. But you want to wait about 6 months, because remember there's statute of limitations on every crime as well. And prosecutors have a certain amount of time. Now for misdemeanors, it's 2 years. So isn't it interesting that it's 2 years for misdemeanors and 2 years for civil suits? I think the civil side should be a little bit further, because as soon as you file a civil suit, a lot of these tyrants are going to go and start charging you with other criminal activities. It happened to me and Jason down there in Aransas Pass. You know, we filed our lawsuit, and after we filed our lawsuit, 10 days later, even though 10 days later was really 5 months after the incident happened, 10 days later, they filed charges on me and Jason. Because it was still within the statute of limitations of that misdemeanor. So I say it's always good policy to wait 6 or 8 months, or even if you can, wait about a year, and then file your case, your lawsuit. Because my argument as an attorney would be, if I file my lawsuit a year after something happens, and especially if it's like a misdemeanor that they're trying to charge you with, and then after I file my lawsuit, they come and charge you with a crime and have you arrested on a pocket warrant or something like that, then it's very easy to go to the judge and argue retaliation at that point. Because why did you wait a year on a misdemeanor to arrest this guy? And is it just coincidental that the arrest and the charges being filed after you're sued in civil court? And that's what we're going to be using in this case down in Aransas Pass. I mean, why did he wait 4 months to cite me and Jason, and that was 10 days after we filed our lawsuit against him and had him, actually, no, it was more than 10 days after we filed our lawsuit, but it was 10 days after we had him served the lawsuit. So, all right, guys, I'm going to let y'all go. I wanted to keep this at a half an hour. You guys take care, be safe, be free. I need to get home because I've got a 2-hour drive. And Dolly, thank you for that $5. Thank you for helping. Let me heart that there. And oh, there's another one I didn't heart. There we go. So thank you for that. Is it with the statute of limitations still? Yes. So 2 years. Just remember, 2 years, 2 years, 2 years, 2 years. The only thing really when it comes to civil that is not 2 years is contracts. A contract is 4 years. And here's how you toll contracts. And let me tell you, this is a quick little tidbit. This is a bonus extra for those of you still hanging on. Let's say you have a contract case, right? And that 4 years has expired, but you're like, man, I keep giving this guy, he keeps saying, oh, give me another month, give me a few months. Next thing you know, it's 4 years. And then you're like, hey, wait, I need to sue this guy. But it's outside the 4 years, and he's just going to claim that the statute of limitations is run, so there's no subject matter jurisdiction for the court. So what you do is like, hey man, can you at least make small payments on this loan? You owe me like $500 or something. I mean, can you at least make like a $25 payment towards it? Just something to, and then once they make that $25 payment, boom, you've just reset the statute of limitations. So the statute of limitations tolls on a loan or a debt starting the last day or the day that the last payment was made. I just won a case here in Bell County. Well, I'm not in Bell County, but back in Bell County where I'm from, I just won a giant $67,000 judgment. And they were trying to get out of it by saying, oh, it's been more than 4 years. Yeah, but your client made the last payment 2 years ago. So really, we have 2 more years to file this lawsuit. So just so you know, little tidbit there on tolling. If you've got a debt, try to convince the person that owes you money to make a payment on that. Now, don't say, hey, look, if you can just make a $20 payment, we'll let it go. Because then that's essentially an oral contract, and you're giving up one thing, he's paying into one thing. And if only one party is, lying about the incident, well, the court's going to rule in the defendant's favor, because you made him believe that if you made a $20 payment, that you were essentially going to forgive it. So don't do that. Just say, hey, can you just give me, like, I'm really hurting right now. Can you give me like at least $20 or $25 towards what you owe me, so I can go and take my wife out to Taco Bell or something? And then once he gives you $25 on that debt, he's just admitted again that he's making payments on a debt that he recognizes, and you're able to revive that. No payments debt collectors go away after 4 years. If you can convince a debt collector not to sue you within 4 years, then yes, after 4 years, 4 years after you make your last payment, technically, they can't sue you for it. And if they do, you just file a motion to dismiss because the statute of limitations is run, and you get out of that debt. But most of these companies know these sorts of rules, and if it gets to collections, of course that's going to go on your record. And then after 4, they can sit there and send you letters all day long. But when it comes to filing a lawsuit against you, it's 4 years. Since your last payment. So if you made a payment within 4 years, just know that's when it tolls. But yeah, I mean, if you can get away with, and I'm not saying do this, that's dishonest. People make loans and give money to people for a reason. They expect to get paid back, and that is a contract. You don't want to be known as a guy who doesn't honor his contracts. But if you don't pay on that for 4 years and they haven't sued you within 4 years, they can't sue you. Period. That's including credit card debt, houses, cars, personal loans, student loans, whatever, unless you sign some contract that, like for student loans right now, some people, because of their income, they have a student loan, but the contract is a $0 payment. So just because you don't pay on that student loan for 4 years doesn't mean that you don't still owe the money, because technically there's a contract there that you are paying on a monthly basis. It's just the amount you're paying is zero. And so that keeps that contract going and going. You see how these things work? These are interesting. All right, guys, take care, be safe, be free. I'm going to get off this time. I got to get home. I'm going to go watch Wolverine or Deadpool and Wolverine.